Okay, so let's look at the general defence of insanity. And I'm going to do what I've started to do with most of these now, which is to try and keep them down to 6 or 7 minutes and do a number of videos. So the first video in this sequence is just going to look at the rationale behind the insanity defence, to look at where it sits in the order of defences, and to sort of look at what happens if you are successful. What are the outcomes for you? So as ever, it's just worth starting with our sort of terms of reference. And the first thing that's worth saying is that it forms part of the family of incapacity defences, along with automatism and unfitness to plead and fitness to plead and intoxication, of course. That notion that you are incapable of doing something, a bit like these turtles are incapable of getting over onto their fronts. You're incapable of doing something, whether that be form the mens rea or form the actus reus, and therefore the defence comes about because it's rationale. The defendant is unable to control his movements or behaviour, his conduct is involuntary and should not lead to criminal liability. All right, so that's where it sits. And the second is about this notion of insane automatism and non-insane automatism. We talk about insanity and we talk about automatism. But the real wording of these defences is that they are both automatism defences. Insanity is insane automatism, and automatism itself is non-insane automatism. All that we've done is we've shortened them by taking these words out to make them easier for us to remember. But if you can always just bear in your mind that when people talk about insane automatism or non-insane automatism, they're just talking about the same things that we are, insanity and automatism. And the third thing is to think about the different outcomes. It's not 3 different outcomes, obviously that's 1, 2, 3, but the different outcomes, and there are 2. Insanity equals a special verdict, okay, and that is not guilty, so not guilty by reason of insanity. All right, whereas automatism equals acquittal. So not only is the terminology different, but also the outcomes. Insanity gives you a special verdict of not guilty by reason of insanity, and we'll see what that means when we look at the disposal, and automatism leads to an automatic acquittal. So if we start here and look at insanity versus automatism, let's have a look about why they are different. And we'll use this little chart here. What you can see is a sort of flow chart. Insanity as a defence is governed by something known as the M'Naughton rules, and we'll look at the M'Naughton rules in the next video. And the M'Naughton rules are very, very clear in that insanity comes about because of internal causes, because of things that are wrong with you internally, because of things that are wrong with your mind. Automatism, on the other hand, is a common law defence that has been developed over the years through case law, and its key factor is it is brought about by external causes, things that happen to you that are not part of your own makeup and your own body. So in this instance, this would be sort of some form of disease perhaps, and this might be something like a blow to the head. You can see the blow to the head is an external cause, a disease is an internal cause. It's not quite as simple as that, but we'll look at how that evolves when we look at later videos. But the key thing to remember is that in both cases there is a loss of control and or consciousness. The person, the defendant, does not know what they're doing. They cannot control their actions. Their actions become involuntary, and because they are involuntary, they can't control them. It means that they should be acquitted. So let's have a look at the key rules then for insanity. So we're talking about insanity now, remember. We will look at automatism in a separate video. These are about insanity. And the first thing to say is that as a defence, it is only relevant, or it is relevant only at the time of the offence. That's all that the court is concerned about. Was the insanity present at the time of the offence? It doesn't matter if it was there 4 or 5 years ago. It doesn't matter if it's there subsequent. It's at the time that the offence is committed. The second thing to say, it is only relevant if the defendant stands trial. So when they get to court, that is when the plea is made of insanity. The third thing to say, where it gets a little bit complex, is that the balance of probability rests with the defendant. The burden of proof rests with the defendant on the balance of probabilities. All right, so if the defendant brings a defence of insanity to court, it is on them to prove that they are insane, and they will only do so, or they only have to do so, to a standard of proof that is the balance of probabilities. However, if the prosecution wants to introduce it, then what has to happen is they have to prove it beyond all reasonable doubt. So the standard for prosecution is beyond all reasonable doubt. And the reason for that is very clear. Because everyone is presumed to be sane, the prosecution, on who the burden of guilt or innocence falls to prove, has to prove that somebody is insane beyond all reasonable doubt. If you as the defendant are claiming that you are insane, your standard of proof becomes much less. And we've already discussed that if we are successful, it gives us a special verdict of not guilty by reason of insanity. Not guilty by reason of insanity. It's now, and to be fair, it is now rarely used. It was used when the death penalty was in existence, and the alternate verdict of not guilty by reason of insanity was far more preferable to death. But since the death penalty is no longer with us, then the alternate verdict of not guilty by reason of insanity is not so attractive. And we'll see why. Because we have to look at, in order to understand that, we have to look at the disposal. And the disposal comes under the rules in the Criminal Procedure Insanity and Unfitness to Plead Act 1991, which amended Section 5 of the Criminal Procedures Insanity Act 1964. And what that basically says is that there are 5 key disposals for somebody that has a successful plea of insanity. At the most severe end, there is a hospital order with no time limit, so you can be in there for the rest of your life, and that is mandatory for murder crimes. So successful insanity pleas for a murder crime means that you have a hospital order in which there is no time limit. For lesser offences, you can have a hospital order with a time limit for X number of years. As we go down the scale in terms of seriousness, we could find a guardianship order is awarded, where you become the ward of somebody. Somebody has to look after you. Fourthly, you could be given a supervision and treatment order, which is you might have to report, somebody might have to check up on you every now and again, and you may have to go for specific psychological treatment. And fifthly, of course, you could have an absolute discharge. Now, if we come back to this notion here of not guilty by reason of insanity, particularly when the death penalty is, it would have been okay to be labelled insane and to spend time in a hospital rather than be hung. But of course, as hanging, as the death penalty is no longer an option in British law, you have to question whether or not the alternate, which is be deemed to be insane and spend time in hospital, is a more preferable option. And as we'll see when we look at the homicide videos, there is a partial defence of diminished responsibility in which you are not labelled insane but still gives you some level of defence against murder. Okay, so that's the background. What we'll do in the next video is we'll go and look at the rules. We'll go and look at the McNaughton rules. We'll explain the McNaughton case and we'll explain the 3 main criteria for a successful plea of insanity.